Right, okay, if you're ready, Stacey, we'll kick off. So, good morning, everybody. I'm Laura Gage from the North East Automotive Alliance. Thank you for joining us for today's session on the changes to state aid post-Brexit. We're delighted to be joined by NEA member Square One Law, who are going to take us through some of the changes that are happening as a result of exiting the EU, and perhaps some of the future plans that we might see take shape as we move forward. If you've got any questions throughout the session, you can just post these in the chat facility and we'll field those at the end with the team at Square One Law. So I'd just like to hand over to Stacey Gray, who's a senior associate at Square One Law, who's going to take us through today's session. Thank you, Stacey.
Hi everyone, can you hear me?
Yes, that's
great. Well, bit of an introduction. Thank you, Laura. So as Laura said, I'm Stacey Gray, Senior Associate at Square One Law, and Square One Law is a law firm. We've got offices in Newcastle, Leeds and Teesside. So today's webinar, we're going to be focusing on the changes to state aid rules following the end of the Brexit transition period. So post-Brexit, but more importantly, post-Brexit transition. I'm going to present some key points and give detail on some of the key changes. There've been a lot of changes, so I'm going to try and keep this as practical as possible. And then towards the end, we'll have an opportunity and a time for questions. So I think it's important just to start with a bit of context and a bit of background. So end of last year, 31st of December, we officially ended the Brexit transition period. So January 2020 was when we left the EU, but then we had an 11-month period where the rules and laws of the EU still continued to apply in the UK. Then on Christmas Eve, you'll all remember that there was the sort of everyone trying to get the deal done, and what that was all about was getting the trade and cooperation agreement in place between the UK and the EU. So that happened Christmas Eve, and that then took effect on the 1st of January 2021 this year. As a result of that, the EU state aid rules no longer apply to the UK in most situations, although later on I'll describe some circumstances where they still do apply for the time being. We also now need to, instead of using the terminology state aid, shift to subsidy control as being the correct terminology. State aid is an EU law concept. So for the purposes of the UK now, and what you'll start seeing in any documents you get from public authorities, local authorities, government, things like that to do with grant funding, you'll start seeing them asking you to start considering your position in relation to subsidy control rules. And basically that is just them saying, okay, you need to do your state aid analysis, but we're not calling it that anymore. It's now about looking at what we need to do from the UK perspective rather than an EU perspective. So in the UK-EU Trade and Cooperation Agreement that's now in place, there is a power and an obligation in there. So on domestic subsidy control regime. However, at the minute we're in this sort of limbo in-between period, I've called it, because although the EU state aid rules no longer apply, we haven't actually yet designed our own domestic regime, because there basically hasn't been enough time, because this was all agreed on Christmas Eve, and the government are now just starting to pull together a team to start sort of consulting on what we need to do to get our own regime. So for the time being, what that means is that when we're asked about a state aid or subsidy control analysis, what we need to do is look directly to the trade and cooperation agreement that's now in place between the UK and the EU. And in there, there's a set of principles that we need to be assessing whenever we're receiving or someone is giving us grant funding. So I'll talk about that in a bit more detail on a later slide, but sort of even though we're in this in-between period, it doesn't mean that the rules don't apply. It means that we have a sort of principles-based approach where we need to be doing a specific assessment that fits in with the principles that are stated specifically in the trade and cooperation agreement. So the current legal framework, if we summarise that sort of, because we need to think broader than just the EU, because we have relationships not just with the EU in terms of trade, we have sort of relationships all around the world. But the main focus of today's session is going to be that EU agreement that we now have in place, because that's where the main change is. But I also wanted to flag to you that when we're talking about subsidy control, there is another important document, an agreement that we entered into many years ago in 1995 with the World Trade Organization, which is their agreement on subsidies and countervailing measures. Now that applies to when we're trading in goods or when a project is about goods rather than services, and when we're receiving subsidies in relation to doing that goods-based project. There's a couple of important rules in the WTO rules. However, I guess the important point to flag, and what I'll talk a bit more in detail about later, is that we've had to comply with this agreement since 1995 anyway, so whatever we're doing should already be compliant with this. It's not a new obligation or anything. And generally speaking, the reason that we're not really aware and haven't been sort of made to focus on the WTO rules when we're talking about state aid and subsidy control is because they're much looser rules, you know, to be frank, compared to what the EU state aid rules. So if you were complying with the EU state aid rules, you were sort of by default already more or less complying with the WTO rules. In practice, that's how it sort of has worked. There should have always been separate analysis going on, but because the EU rules were so much stricter, that's why we never sort of had to bring our attention to the WTO rules before. And that's probably going to be the same going forward, as in it will be probably the case that the UK-EU Trade and Cooperation Agreement and the work that we do assessing any subsidies in relation to those principles, that's probably going to be the key piece of work still for us all to do when we're dealing with subsidy control. But because there's been a change, I think it's important to flag what other rules are out there that we need to just be mindful of. And of course, there's loads of other free trade agreements around the world that we have in place. But, you know, I think we need to focus sort of importantly on what has changed at the moment and realistically what we're going to be asked by public authorities and local authorities to be looking at. And the reality is it's going to be this UK EU trade and cooperation agreement that they're going to be asking us to do our state aid analysis now on. So a little bit of a summary of the key points of the TCA, so I'll just abbreviate it to TCA from now on. So as I say, it imposes this obligation on us, on the UK government specifically, to design a domestic regime, but we're not there yet. But that regime has to comply with certain principles in the TCA. So that's why, even though we don't have our own regime at the minute, that local authorities are asking everybody who is receiving grant funding or any sort of subsidy to do an assessment as against those principles, because I think the idea is that even though we don't have a regime, we're going to design a regime that complies with those principles. So as long as we're applying these principles from day one, then there shouldn't be any problem going forward sort of with things that are given subsidies right now before the regime's in place. An interesting point in the TCA is that for those of you that are familiar with the EU state aid rules, there used to be what was called a de minimis provision, which was basically businesses, companies could receive up to 200,000 euros, sort of an equivalent of GBP, over a 3-year rolling period. And as long as you didn't exceed that amount, you didn't need to be bothered about doing any sort of state aid analysis because you were exempt. It was deemed sort of too small of an amount to be significant in terms of how it affects trade. So that a similar provision has been put into the TCA. However, the good news is they've increased that amount, and instead of being €200,000 over those 3 years, it's nearly doubled. So it's €380,000 at the minute, which I double checked this morning on what the conversion is on the specific site that we'll look at, and that works out at about £335,000 in terms of funding that you can receive over 3 years without even triggering a subsidy control analysis. The definition of what a subsidy is pretty much the same as what state aid was. So we're talking about public grant funding, loans on preferential rates, special tax treatment or waivers, debt write-offs. But I know that in practice, and certainly a lot of the advice I give in practice tends to be on grant funding from public authorities, whether that's central government or local government. So now I imagine that's where most of your work is as well. And then the last point on this slide, that a subsidy must also convert an advantage and be specific. I guess the point I'm making there is that this is again similar to the position under EU state aid rules that always had to be, it was the purpose of the state aid regime is to make sure that specific companies aren't being overly rewarded or over assisted by government. So it was all about, you had to look, was there an advantage being given? Was there an actual benefit in this case? And with grant funding, there pretty much always is, because you're getting money for free. You're not having to pay it back. And is it specific, as in, is that grant funding being directed towards a company, or is it a measure that absolutely everyone in the country is going to be entitled to, in which case you would say, well, it's not actually specific, so we're not caught by the rules. But basically, any grant funding that you receive as a company, I'd say the starting point is that it's likely to be caught in principle by both the state aid rules and now the TCA principles. So that position doesn't change. So the principles that we have here, so there's 6 main principles that are in the TCA. And what I've seen from the work that I've been doing since January, when I've been asked by clients to help out on their subsidy control analysis, is we seem to be being presented with a table which sets out these 6 points and asked to do an analysis in relation to each of them. So I guess as a takeaway from today, I'd say this slide number 5 is really important and is probably the format in which you're going to be asked, if you are asked by a funder to do your analysis. And it basically is asking for you to have a look at your project, have a look at the funding that you're asking for, and working out how your project or investment or whatever it is complies with each of these 6 principles. Now, I won't go through all of the principles in details. A lot of it is very similar to the approach under the EU state aid rules, but the overarching principle, I would say, that goes through all 6 of them, and what you need to be keeping in your mind when you're writing your analysis or asking a lawyer to help you out with one, that the main thing we're going to be thinking about is that the question is, without the subsidy that you're going to get, would the investment happen anyway, and would it happen in the same way? Because the point is that subsidies are only supposed to be given in order to help projects be funded that otherwise might not go ahead, or that they wouldn't go ahead in the same way, or that they'd be much more difficult to go ahead. So it's all about helping. It's sort of not about just giving grant funding for the sake of it. So that's the principle behind all of this, is the sort of, whether it's central government or local government, they're going to want to see an analysis which demonstrates the benefits that this project is going to bring, but also why the project or the investment wouldn't be able to happen in the same way in the absence of a subsidy. So that's sort of like the overarching point that really runs through all 6 of those. but just so you aren't daunted if he's getting in an email from a funder saying, okay, you now need to do your assessment and it needs to be against all these 6 points, because it does look quite overwhelming when I saw it on the email at first and you're not familiar with it. You're like, oh, okay, well, where are these points coming from? But just reassurance that actually what they are is that they're pulled directly from the Trade and Cooperation Agreement, and it's the 6 principles that all funding has to apply by now in what our regime will be designed to comply with. And they're wanting sort of an analysis done which demonstrates to them that they can have reassurance that when they're given this funding that they're doing it in compliance with the new rules. The difficulty at the minute, I guess, is that because this is all brand new, we don't really have any case analysis or any sort of historic information to be working on when we're doing this analysis. It's sort of all brand new. There isn't a huge amount of guidance out there. There's 2 technical documents on the government website about subsidy control, and those are helpful, but they don't really describe how you do the assessment for these principles. They just state that the assessment is necessary. So I think it's a bit of a job, and it's something that I think we'll all be learning over the next few months how to do in the best way possible. And equally, BIS, the government department who is responsible for all this, I think they're learning to see what is going to be required in terms of the analysis. But I guess the important thing that we need to be doing is making sure that we are sort of satisfied that we're giving answers that are true and accurate and that are reasonable and reasoned. And I guess that's where sort of it's a bit of a balance between business people in the business coming together who understand the project, and then lawyers coming and giving their advice on how it's being presented and how it's being worded in a way that's going to be most helpful when it's presented to government lawyers who are going to do their assessment on whether or not your project complies with the principles. So I'd star that slide for your records, but afterwards we're going to send the slides around anyway. But I think that's going to be a handy little sort of slide to keep to one side for your records if any years are in charge of doing the subsidy control stuff within your business. So I mentioned that the EU state aid rules still do apply in some limited circumstances, and the 2 main circumstances, and really the 2 ones that you need to be most aware of, are where you have projects which are still receiving funding through existing EU funding schemes. So there was a thing called the 2014 to 2020 multi-annual framework with the EU, which was basically pots of money that have been made available for projects throughout the EU and delegated to the UK for the time we were in the EU. And the 2 main ones were the European Social Fund, which you often see abbreviated to the ESF, and the European Regional Development Fund, ERDF. And I know a lot of projects that I've seen over the last few years, that it's often been grant funding in relation to these 2 pots of money. So to the extent that your project is still tapping into these pots, you still need to follow the EU state aid rules. But what I have seen is that sometimes that the government is asking both for an analysis under the EU state aid rules, and then on top of that the new analysis under the TCA I think everyone's still trying to work it out a bit, but strictly speaking, the analysis that is required is the EU state aid law analysis for these 2 pots of money. And the reason for that is because the rules say quite clearly that these funds and anyone receiving funds from these 2 pots need to apply with all applicable EU law until the closure of those programmes, and obviously that includes EU state aid rules because that's EU law. Now, the other point where we might still need to think about EU state aid rules, and this could be something that goes forward for quite a while, unlike the pots of money point I've just made, which are more time limited because they will end at some point. Whereas for the time being, we have the Northern Ireland Protocol also in place, which was part of the Brexit sort of negotiations and one of the outcomes. And as part of that, the EU state aid rules still can apply whenever there's trade which involves Northern Ireland. There's certain conditions that have to be made and have to be met in order for you to be applying the EU rules still. But what I'd say is that just to sort of keep as a bit of a red flag to the extent that any of your business might relate to Northern Ireland, is that there's still a possibility that you have to comply with EU law generally. And for the purposes of today's talk, that means the EU state aid rules. And it's where there's a sort of a direct and a genuine link to Northern Ireland, and where that link means that there's a real and foreseeable impact on the trade between Northern Ireland and the EU. So there's a couple of conditions that need to be met there. Now, as I mentioned, there's the World Trade Organization agreement as well. That is something that we need to be aware of, but in practice has actually applied since 1995, or end of 1994 actually. So I won't go through this in much detail, but I've just put one slide on there now for you, just so you know what the key points are. This agreement only applies to subsidies in the context of goods. So to the extent a project or what's being done is to do with services, you don't really need to be thinking about the WTO rules as a general starting point. So it's when goods are the main subject, and they are looser rules than the EU state aid rules and the trade and cooperation agreement. And I'd imagine whatever domestic regime is finally designed by the UK will also be stricter than the WTO rules. Perhaps it won't be as strict as the EU regime, but I think the way it's looking is that it's still going to be strict enough to cover off these points automatically. But I guess for sort of a belt and braces approach to any analysis, it's useful just to make sure that these points are covered off if you're asked about subsidy control in a more international context. And the main rules are basically there are two prohibited categories of subsidies, those which are dependent on export performance and those which are contingent on the use of any domestic content. So I've put a couple of examples on there, but so that you can read it in more detail as sort of some worked examples. But the basic position is anything where there's sort of it's conditionality on export performance or specific use of domestic content, your subsidy is probably going to be in breach of the WTO rules. But apart from that, the rules aren't quite as strict, so perhaps don't need as much attention as the trade and cooperation agreement analysis, which is, I think, what everyone's going to be asked to be doing going forward, as the main piece of work on any subsidy control work. And just the point there that these aren't new obligations, so we don't need to be being worried. It's just for good measure, just to make sure that we're aware of it, and it also means that we're informed as well, and useful if we're having conversations with colleagues, that we sort of have the broader picture of sort of how subsidy control works now in an international context in the UK. So final piece of information from me before we go on to some questions, should you have any, is that the Department for Business, Energy and Industrial Strategy, so BEIS, it's one of the government departments, at the beginning of February the 8th it was, I think, they published a consultation paper on gov.uk asking for responses, looking for views from stakeholders on what the new subsidy control regime should look like. So the consultation is still open, and it is open till midnight on the 31st of March. And anyone can put their views forward if you have a view. Basically, there is the consultation paper is called Subsidy Control, Designing a New Approach for the UK, and it's easy to find on a Google. But what I've put up there is useful links on how to submit your views. Just if you have anything that you did want to say, the idea is that all of the views will be collated, and the government seems to be quite interested now in how it can help out the regions a bit more and what subsidies would be most helpful in the regions as part of what I'm sure you've all heard is called the Levelling Up agenda. So there's a bit of an opportunity now, I think, that perhaps government is listening a bit more than usual or than they have done in the past to how the regions are affected generally and what sort of business support is required in order for the other regions to start thriving. So there's two ways of submitting your views if you did want to. There's an online submission, which is a bit more sort of like filling in a form, and then, or you can just do a direct email to the subsidy control team at BEIS. I'm very happy to help sort of talk you through anything if you need any help on those two things. But the main points are that there's a consultation paper at the back of that paper. There's a list of questions that it says the government are interested in seeking views on, and a lot of them are to do with the regions. So it might be that, you know, if you do have a view on this and you end up doing lots of projects where you do get grant funding and you've noticed difficulties in the past, or, you know, things that come up, a bit of a pattern that you wanted to flag to government, well, here's your opportunity to do it. So we've still got a couple of weeks, I think, have we? Yeah, we've got a couple of weeks until that closes. But that could be a quite a useful tool to use to get views heard. So that is it from me in terms of the presentation element of it. So I thought we could now, to the extent there's any questions, I'm very happy to talk through those. I've got sort of an example of questions that have been asked from clients as well, that can get us started on that. So perhaps that's what I'll do to start with, and people can have a little think about whether or not there's anything they'd like to ask. But one of the big questions, understandably so, that I've been getting asked from clients is how subsidy control now works in relation to COVID-19 business support. So I think there's been a bit of confusion over the last few weeks in particular about what rules actually apply in relation to all these business support grants and pots of money that are being made available to businesses in light of COVID-19. And up until the end of the year, when we're still part of the EU rules, there was quite a clear regime that we applied there with clear thresholds and limits, and I think local authorities are quite familiar with what needed to be applied and what the specific thresholds were financially that people couldn't exceed. And then we went into a bit of a grey area where it wasn't very clear at all whether or not we still needed to be complying with EU rules or whether or not we needed to be complying with these new TCA principles. And if we did, what did that actually mean in terms of how much money each business could receive in terms of COVID support? Interestingly, they've just on the 4th of March, the government's updated their business support package document, which is available again on gov.uk. And so they have a document which sets out how this all now works. And what they've made clear is that going forward, any business support that is required is now going to be assessed under the TCA and not the EU state aid rules. And it's like a 3-stage approach. So you basically have stage 1 is businesses can receive up to 335,000 over 3 years. So that's that principle that I mentioned on the earlier slide that comes now from the TCA to do with de minimis. So you can receive up to 335,000 over 3 years and you don't trigger any of the subsidy control rules. Pot number 2 is it's called the COVID-19 business grant allowance. So once you've reached your de minimis threshold, there's now an ability to receive more money on top of that, up to 1.6 million in total, if you're eligible with all the other conditions. But in terms of subsidy control, you can get up to 1.6 million and still be within the subsidy control thresholds, and that's okay. And the way the government have done that is there's a provision in the TCA which allows for support to be given to businesses where it responds to temporary national and global economic events. And then once you get to your 1.6 million, if you're in a situation where you need more funding and are eligible in the other terms of it, there's now a possibility of accessing up to a total of 9 million and still being compliant with the subsidy control rules. But that's a lot more detailed, the analysis that has to go into what you actually need to be doing in order to get the 9 million threshold to apply. But it basically covers uncovered fixed costs of businesses, and you have to show that your turnover has declined by 30% as a result of COVID, basically. But I think the point is to make that sort of, with everything, it's taken a little while for government to really get to grips with what's required with subsidy control now, but there seems to be documents coming out, A, the consultation paper, and B, now a specific document which clearly sets out the position in terms of COVID support. So I think we're going forward going to have an easier time of knowing what rules we need to apply and how to do any analysis. So if anyone has any questions, I'm very happy to answer.
Thanks, Amy. That was excellent. We've had a couple of questions come in. We've also had a few comments from people saying how valuable that information has been to them as well. So a lot to take away. But somebody has asked, how do you see GBER exemptions applying? For example, a grant for environmental protection and the need to apply notification thresholds.
Yeah. So the General Block Exemption Regulation is an EU state aid concept, and it hasn't been transferred across to the TCA. So it's sort of the starting point is those exemptions don't apply in the same way anymore. But what I think is going to happen, and this is just my thinking from having read the Trade and Cooperation Agreement and having a look at the guidance from the document, is I think that we're going to have an approach when the regime is designed which either sets out similar exemptions or has principles in there that we apply which get to more or less the same result. I think it's going to be unlikely that the government is going to create a subsidy control regime in the UK which is stricter than the EU state aid rules, because politically and what's been said up to now, rather than sort of the legal question, but sort of the general sense that we're getting is that there's an appetite to make the rules, now that we've left the EU, to sort of have more control over how we do our own grant funding and how we give our own subsidies. That seems to be the dialogue. Whether or not we agree with that or not is not, that's a matter for, but that's opinion for debate, isn't it? But that seems to be the message that's coming through from government. So I think first point is the exemptions don't apply anymore. So unless you're receiving money from the ESF or the ERDF, so them existing EU pots, still you can be doing your analysis where you apply those exemptions, and that's what will be required to be done. But if you're not getting money from those pots and it's now just going to be pots of money which require you to apply the Trade and Cooperation Agreement principles, I think the idea is that when you're doing your analysis against each of the six principles, is that as part of that you're almost like explaining why, so if environmental is the point, you'd be explaining why that is the first principle talks about there being a public policy objective or a social objective to your project. And to me, it's sort of like in that category that you'd be sort of saying, okay, well, the objective of this project is actually to do with environmental benefits, environmental concerns, and sort of that's how you're sort of going to be applying how you would have almost been applying an exemption. But very happy sort of when if specific sort of projects come up to have a look at that and see what needs to be written. But you're very right that, you know, GBA was the big piece of the puzzle that we had for EU state aid, and that was how we often got funding sort of past the post and compliant, is would rely on an exemption, whereas that now longer is it's not what we're doing anymore. But the idea is that when we're writing our assessment against the principles, is that we're almost setting out why sort of the project is exempt, because it has this overarching sort of policy objective, which is really good in relation to whether it's environmental, whether it's local infrastructure, whether it's research and development, like all of the categories that we had of exemption under GBA. But if you need any more detail on that, I'm very happy to answer.
Okay. Stuart, ask your question. If you're there.
Sorry?
Do you want to ask your question?
Yeah, I've got a couple of questions. The first thing I would say is really informative, Stacey. So thanks very much. And Matt Boyle, who's our chairman, sent me a direct message saying great stuff from Stacey. So you've had praise indeed from the top.
Thank you.
So the question is there another European country in the same boat as us? So we can compare and contrast and maybe gather intelligence?
I'd say the closest countries that we have are probably Norway and possibly basically the EFTA countries, the EFTA.
European Free Trade Association.
Exactly. Those are probably the closest examples that we have now. But when I've looked at the EFTA agreements and how that all works, it is a little bit like sort of EU state aid rules by the back door, right, which seems to be a departure from what the UK government wants. It seems that as if the UK wants to really, to the extent it can, leave the EU rules behind and design its own regime, which is
Brexit.
I think so.
Right.
Yeah.
Okay. And the second question was more practical. Who's actually administering the new regime in the Northeast if you want to get a grant?
There's different bodies. So first of all, it'll be your local authorities might have various pots of money. So, you know, Tees Valley Combined Authority,
Northeast LEP,
all the LEPs.
Right.
So at a local level, it's LEPs and combined authorities and sort of county councils, you know, Northumberland County Council.
Right.
That's who you'd be looking for at the very local level. And then more broadly, there are sort of central government initiatives as well. But generally speaking, those do sort of flow through to the local authorities and sort of get administered that way. But I know that like on the gov.uk website, I'm sure there's a page which sort of sets out sort of what pots of money are available generally in terms of grant funding. Mm-hmm. I can have a little look afterwards, but I think there's a central government page to keep a record of what is available. I know definitely in relation to COVID support there is, mm-hmm. But the gov.uk website, generally through Department of Business and Energy and Industrial Strategy. So BEIS is the main people at the minute who are dealing with a lot of this sort of stuff. I'm trying to think.
That's great. So the entry point from anybody who wants to look at this is probably the LEP.
I think LEP,
yeah.
Exactly.
Okay. That's answered my question. Thank you very much.
Welcome.
Just having a look if we cannot refer back to GBER, how can we determine what % grant is proportionate?
Yeah, very good question, and we don't know the answer to that one yet. So it really is about doing some sort of assessment of it and setting out why we think as a business it is proportionate, and we'll look at sort of how it fits into policy, sort of, is there wider public policy about this? Are there government initiatives that are demonstrating why actually this is a really good project that they should be funding? But there aren't thresholds now or intervention rates. Things like that did used to appear in GBA, you're exactly right. That approach now doesn't apply. It's all about assessing your project against those 6 principles in a very, what feels to me, quite a narrative way, a little bit almost like you're writing an essay, if I'm honest. When I've been doing it, it's sort of, you're having to sort of just sit down and go, okay, this is the question I'm being asked. Okay, what is a reasonable response I can put to this that is gonna be picked up, and someone's going to say, that looks fair enough, that looks like someone sat and thought about this, and that is reasonable. So yeah, we're in this in-between period, like I said right at the start, where we don't have a domestic regime that we can apply, but all we can apply are these 6 principles, which is a bit, I know from a lawyer's perspective, it's not, it feels a bit inadequate at times, because it's nice to have rules that we can apply and more guidance. But at the minute we haven't. I think that's why it's important that when you get asked these questions, or when you're asked to do an analysis now, it is perhaps important to be seeking out advice from people in the business who have a really good understanding of what the economic effect of the project is going to be, because that seems to be a big piece of the analysis that's required. And then perhaps a sense check from a lawyer, just to see whether or not, okay, when either local government lawyers pick this up, because that's what will happen, or central government lawyers, are they going to read it, and is there anything there that's just going to sort of put them on notice of this just being so far from what the principles are about? But it's a really sort of grey area at the minute, and I think realistically we're probably looking at another 6 months before we get a domestic regime or a framework for that, if we think the consultation closes at the end of March, and it's going to take them a little while. So I guess what I'd say is, like, don't be afraid to ask questions if you do get this form asking you to assess the principles, and it's sort of, I think it's reasonable to wonder sort of how you're supposed to answer these. I don't think there is a clear answer. So ask questions and seek support, and sort of, you can always drop me an email, or I'm on the end of the phone if you need a little bit of a steer or anything like that on a specific point.
Thanks, Stacey. I think that was been really valuable, and thanks again for your support on this, and you've agreed for us to share the slides afterwards with the attendees, so we will follow up with a PDF copy of the slides in case there's anyone else within your organisations that you'd like to share the information with, and of course we can share contact details if anybody would like to make any further contact. So another thank you from the NEAA. That was a really valuable session. Thank you.
You're very welcome. Thanks for having me.
Thanks everybody. Thank you.
Right, thank you. Bye.